Peace. Greetings to you all. It's your brother Naheem, BKA Lord Abbott, AKA Mr. Just the Facts. You already know. Let's get some housekeeping going on, family. Make sure y'all hit that like button. Share the video out. If you are not subscribed to the channel, if you are watching from Facebook, if you are watching from Twitter, go to the YouTube channel, hit the subscribe button, and hit that little bell icon next to the subscribe button so you could become a part of the notification nation and be informed every time BTP drops that dynamic content. We got the fam in the building. First, of course, I got to bring my bro on, but we got a special guest tonight. We got a special guest. And there's certain people that we've elevated in this space, among ourselves. And this sister right here, we have elevated to royalty in this space, point blank, period. Whether she feels that way or accepts it or not, that's the way we feel about this sister, because she is doing great work for this movement. That's why every time somebody come at her, y'all already know I'm on their head. And some of y'all probably guessing who I'm talking about. So let's introduce our sister Kamilah Moore to the stream. Peace. What's going on, sis? How you doing?
Peace. Hello. Happy to be here. Thanks for having me. Yes, thank you for the kind words.
Oh, definitely. So, it was an eventful day today, family. We had the Supreme Court hearing affirmative action cases. And in that, we have seen the Freedmen being invoked again. The 14th Amendment is at the forefront again. And I want to start I want to read from this article, and then we're going to play Ketanji Brown's piece. And the reason why I want to read from this article, because it was an article that was done before today's hearing. So, Brother Ali, did you have anything you want to share before we get into this?
No, man. Let me know if you can hear me okay, because I'm in the car, so I don't know what it's sounding like.
Oh, no, I hear you perfectly fine, brother. I hear you perfectly fine. Again,
All
make
right,
sure
cool.
y'all hit the like button, share the stream out. Share the stream out. We're gonna have a discussion tonight, and we're gonna touch on some things, because we see that this Supreme Court case dealing with affirmative action, right? I always say, well, let me just go to the case, right? There are several cans of worms being opened with this particular case. And I am of the opinion that one will have a positive impact on the Freedmen moving forward, and the other using originalism, meaning the intent of any act of legislation, as opposed to how it may be construed or used in modern times. Well, I think that is going to benefit us. I think that's going to benefit us as we push forward. Ultimately,
Well, I'll say this.
all right.
I'll say this real quick.
Mm-hmm.
Certain people's interpretations from what I'm seeing and what they're calling originalism is not necessarily favorable. Kamilah could correct me if I'm wrong about that, but certain folks that are making arguments, that are trying to make arguments about the 14th Amendment or the intent of the 1866 Civil Rights Act, which is also a part of it, because the 1866 Civil Rights Act actually informs at least Section 1 of the 14th Amendment. So the legislative intent behind that particular act is going to come into question in terms of whether or not the law was intended to be racially conscious. But Sister Kamilah, if I'm off on that, let me know.
No, I think you're spot on. And we can get into this later, but this is I'm still kind of processing the arguments, and I even intended to re-listen to them. It was like over 5 hours. But you kind of have to re-listen to it to really get a better understanding. But again, what I was going to say is, to me, I don't think it's very clear if the Supreme Court justices fully understand the distinction between race and lineage. Even the justices who we would think, are on our side, like Justice Ketanji Brown and Justice Sotomayor. And I think hindsight being 2020, I think a way to have solved that was for organizations like yourself, or individuals in the reparations space, to submit what they call amicus curiae briefs, or friends of the court briefs, to educate the justices on these distinctions, on the Freedman history, and that could have helped inform the discussion that we heard today. But I'll just stop there.
It's so ironic, because I was thinking the same thing in this article that I'm going to read from. It speaks about these friend of the court briefs that are filed on behalf of whoever, right? And as I listened to Ketanji Brown Jackson, an excerpt today, my initial thoughts was that she's grounding her arguments in the status of Freedmen, but it's convoluted because she's still making a racial argument. That's why I made a tweet some months back when, I think this was last month, I think, where she spoke about race consciousness, right? And what was that in regard to? What was that in regard to? I can't remember at the moment. It may have been leading up to this particular case. I just can't remember at the moment. And I kind of had a problem with the term race consciousness. Me and Brother Ali spoke about it on the back channel, but I feel that she is crafting her arguments in our political status without understanding it, right? Going to what you're saying insofar as our ancestry, the ancestry of our particular population is concerned, but we like to confine it to the term status as opposed to looking at it from the ancestral or lineage based perspective when we're speaking to it from its strict legal interpretation, right? And I'm going to get into a little bit of that later to, just show why at least I feel that way. So let's get into this article, family. Let me put the link in the chat. Y'all know how we do. Again, for those of you just coming in, make sure y'all hit that like button, share the video out, subscribe to the channel, etc., etc., etc. Okay, yes, that's right. She said the history of the Voting Rights Act and the 14th Amendment were race conscious. And that's exactly right. And that's what we're basically discussing today, the race consciousness of the 14th Amendment. And if affirmative action is necessarily grounded or rooted in the 14th Amendment or civil rights legislation in and of itself. And at least that's my view and interpretation of it. And we're going to open it up. Let me just read from this article, and I'm going to let those who have more knowledge than I do on this subject start breaking it down. Let's read from this article first. Is the 14th Amendment colorblind? And shout out to our sister Shanna, because she put this in the chat. It was a link to a tweet that, what was it called? The Independent, I believe, or I can't remember the name of the organization, but they spoke about how the Supreme Court was going to be arguing if the term Freedman is constitutional to some degree. And I'll pull the tweet up so I could quote it correctly. I just want to get through this so that we can start having the dialogue. Let me see. I want to start here. Edwin Meese, a former attorney general in the Reagan administration, filed a brief arguing that the 14th Amendment had transformed the Constitution into a quote unquote colorblind document. Meese is a heavyweight in the conservative legal movement, having played a key role in the formulation of originalism as a method of constitutional interpretation in the 1980s. He also oversaw the Justice Department at a time when young conservative lawyers were getting their first taste of exercising power in Washington, among them Chief Justice John Roberts. As expected, Meese adopted an originalist lens in his brief, drawing upon what he saw as the quote-unquote original public meaning of the 14th Amendment at the time of its ratification. To understand that, he pointed to how the ratifying Congress approached civil rights legislation in general. Quote, the principles of eventually enshrined in the 14th Amendment were sown in the Civil Rights Act of 1866.
Exactly.
Meese argued. And he's right. It's a double-edged sword when you kind of look at what he's saying, right? The colorblind thing is just simply false.
Yeah, I wanted to say something about that, but go ahead, finish what you're doing.
All right. So, okay, it says, quote, because of one, uncertainty about Congress's authority to pass the 1866 Act, and two, fear that a subsequent Congress would unravel it, the 39th Congress preserved the Act's tenets by constitutionalizing them. For that reason, the debate surrounding the 1866 Act necessarily informed the original understanding of the amendment itself. That is key in so many ways. And this conservative is the one who is making these arguments, right? And like I said, it's a double-edged sword, but we're going to get to it. On the 1866 Act, the article continues. He wrote that lawmakers initially thought that the bill would be colorblind, noting that they claimed in debates that it could even forbid laws that segregate schools or ban interracial marriages. Quote, as originally introduced in the 39th Congress, the 1866 Act conveyed the general principle that, quote, there shall be no discrimination in civil rights or immunities among the inhabitants of any state or territory of the United States on account of race, color, or previous condition of slavery, Meese noted. In other briefs, a group of historians and law professors disputed Meese's understanding of the historical record.
That's right.
That's right. They took particular issue with his citation of the 1866 Act as introduced instead of the final version that Congress approved. That's
that trick knowledge.
That trick knowledge. That's that trick knowledge. That serpent. Right? Okay, quote. In fact, the first drafts on account of race language did not make it into the final bill, they pointed out. Quote, the actual text of the enacted Civil Rights Act of 1866 explicitly acknowledged that white citizens had certain rights and were treated as privileged class and required that non-white citizens be permitted to enjoy those rights. To that end, they quoted from Section 1 of the 1866 Act, which said that people, quote, of every race and color shall have the same right to make and enforce contracts, to sue, to be parties, and give evidence to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property as is enjoyed by white citizens. That is so key and pivotal. So key. Section 2 made it a misdemeanor for state and local officials to punish Americans on account of their race differently from what is prescribed for the punishment of white persons. The scholars noted that President Andrew Johnson vetoed the bill because he thought it would provide, quote, discriminating protection to colored persons, especially in Section 2, but Congress overrode his veto. Those of us that know the history know that. So this is where it gets interesting, right? To argue that the 14th Amendment, well, all of it is interesting, but we are so Freedman specific, I had to, throw that in there. To argue that the 14th Amendment's drafters had intended to allow some forms of race-conscious legislation, the scholars pointed to contemporary laws that appeared to take that approach. The Reconstruction-era Congress created the Freedmen's Bureau and the Freedmen's Savings and Trust Bank to help formerly enslaved Americans. So we have some discrimination here, right? Some good discrimination. And we're going to get into the congressional records and what what was that, Ali? The Commission on Freedmen Affairs said.
The American Freedmen's Inquiry Commission.
The American Freedmen's Inquiry Commission said in that regard. Something y'all have heard us bring up on this platform before, right? It continues. It passed laws that explicitly targeted financial fraud schemes against Black veterans, provided special chaplain services for Black regiments, and provided funding to charities that specifically helped Black orphans and paupers, right? We look at targeted financial fraud schemes against Black veterans, and we think about the Citigroup report that came out that showed where they concluded that since the year 2000, the American economy lost $16 trillion due to racial discrimination against African Americans, using their words. Just like the Civil Rights Act and Freedmen's Bureau Act of 1866, these legislative efforts confirm that the Reconstruction framers did not have an unbending vision of colorblindness. The scholars concluded, rather, quote, they believe that race-conscious measures to ensure equality of opportunity were necessary to ameliorate the harms inflicted through generations of racial subjugation, i.e., e.g., the badges and incidents of slavery, some of which we still suffer from today. And the concluding chapter says, Mies submitted his brief before the scholars did. So he did not directly reply to them, but he did anticipate the use of some of the evidence that they offered for a race-conscious 14th Amendment. That serpent. He argued that while the Reconstruction-era Congress did pass some laws to benefit formerly enslaved Americans, these should not be understood as race-conscious laws. And for me, that's all right. I'll get to that part. Properly understood, however, the Freedmen's Bureau Acts were not race-based, Mies claimed. Although the term freedmen referred to former slaves and virtually all former slaves were Black, the triggering characteristic for receipt of government assistance was not skin color alone. By its terms, the Freedmen's Bureau Act did not help African Americans who were not enslaved before the Civil War. So there's so many different points to touch on. Brother Ali, I want to go to you, and then I want Sister Kamilah to just come in and give some commentary based on this article and based on some of what you're saying.
Okay, so firstly, one of the things that I've realized that we're going to have to do is we're going to have to combat these people, right? These are people who are anti-justice, that are let's just be clear. They're anti-justice specifically for our people. Specifically for our people. There's this inherent I don't know, hatred that they have for us, and they really by any means will do whatever they got to do to ensure that you don't get the justice and the remedy that you so desperately need and seek, right? So that's the first thing. What I see in this is language, right? One of the things that I'm realizing as I'm listening to these people is that language obviously is going to play a major role in the administration of justice, the proper administration of justice. Language, right? This is what we're doing. We're playing word, like ultimately we're really playing a battle of words with these people and what these words mean in the end, right? What does it mean to be a descendant of slaves? What does it mean to be freedmen? Or what does it mean for us today as freedmen families, American freedmen families? What does that mean? What does it mean to the court when they talk about strict scrutiny and a compelling governmental interest, and whether or not the 14th Amendment is race conscious? First of all, I look at it like this, right? The fact that they're trying to argue that the 14th Amendment, and when I think about that, I'm thinking about the actual text. The text of the 14th Amendment is not race specific, even though they're trying to pretend that it is at this point, right? Because they're trying to make a certain point against affirmative action, which is an outgrowth, obviously, of this particular amendment. But the thing about it is the language of the amendment itself is not race specific. Section 1 says all persons born or naturalized, yada, yada, yada. It doesn't say all black persons born. It doesn't say all Negroes born, all persons of African descent. It doesn't say anything like that. It says all persons born. So that's number one. The language itself is not race specific. Was Thaddeus Stevens and John Bingham and people of that sort, were they conscious of the consequences of these imposed racial classifications of Negro and black and colored and mulatto and African? Were they conscious of the consequences of those things? Absolutely. Were they attempting to address the consequences of these imposed classifications on our people? Yeah, I would say that they were, but it's not in the text of the language other than the 1866 Civil Rights Act, which actually is conscious of whiteness. If it's conscious of anything, it's conscious of whiteness, right? Because white is what's mentioned in the text of the language. So that's the thing that immediately comes to mind there. And then the second thing, the guy mentioned that the 14th Amendment takes the Constitution away from being race conscious. Basically, I think he said it made the Constitution colorblind. Well, first of all, the Constitution doesn't say anything about race or color. The original Constitution, before these amendments, it doesn't say anything about white people. It doesn't say anything about black people. It doesn't say anything about Negroes. The only people who were mentioned by name, and you mentioned this before, we've mentioned it before, was Indians not taxed. Those are the only people mentioned by name. So in terms of race consciousness, there's no mention of white folks, black folks, Negroes, mulattoes, octoroons, Africans, or anything like that in that inside of the text of the Constitution. So it was not race conscious. And for people who really don't believe that, there are two things that you should consider. Number one, during the time that they were looking to adopt the Constitution, coming out of the Articles of Confederation, they were having a debate as to what the preamble should say. What should the preamble actually say? Right? There were certain people who wanted it to say, "We the white people do ordain and establish this Constitution," etc., etc. That was an actual debate. Those people were defeated in that debate. So the Constitution's preamble reads what it reads today: "We the people do ordain and establish." So there's nothing about race in that particular instrument. Number one. Number two, read the Frederick Douglass the breakdown where Frederick Douglass was debating with that attorney over in Europe. It was some attorney from the United States who Frederick Douglass actually had a debate with. Powerful debate. Frederick Douglass actually broke this dude completely down on all of the BS talking points, many of which these people are using today, right now today, same kind of BS arguments. Frederick Douglass broke that stuff down in a live debate with this guy over in the UK back in the 1800s. So we could actually learn something. We could actually learn something from studying that debate between Frederick Douglass and that particular attorney. I can't remember the attorney's name offhand, but it was a debate where he actually broke down the fact that these people were lying about what the Constitution says, the intention behind the Constitution, etc. So that's what I have to say about it for right now.
Indeed. Sister Kamilah, what are your thoughts on that? And then we're going to play the Ketanji Brown Jackson clip that's floating around on the internet.
Yeah, sure. In terms of the article, I think I'm still trying to process whether or not, and I'm just being very transparent, whether or not the 14th Amendment is in fact race conscious or not. I think the Supreme Court justices are actually still trying to figure that out. Of course, someone in the reparations space, someone who has, received political education from BTP, if I had to, make a decision today, I would state, okay, the 14th Amendment is not race conscious. Because as that article pointed out, which I think is a good argument, for instance, when the 14th Amendment was enacted and when the Freedmen's Bureau was constructed, it was for, former slaves, also white refugees. And as that article stated, if you were free before the Civil War, in that article, it states that the Freedmen's Bureau wasn't for you. You wouldn't benefit. There's some people who argue that no, actually, Black people who were freed before the Civil War actually did still benefit from the Freedmen's Bureau. I think that there needs to be some investigation.
That's right.
Some investigation.
I'm gonna get to that. I'm
gonna get to that. Important. So it's cool. We're all on the same page.
Mm-hmm.
So I'll just be brief because I think the more things that I want to say has to relate to, the arguments and not necessarily the article, even though I think the article that you read gives really good context. But generally, I'll just conclude by saying, to be fair, I understand where the justices are coming from, namely Justice Sotomayor and Ketanji Brown Jackson, who are trying to argue that the 14th Amendment is race conscious because they think that is kind of the way to go forward to save affirmative action because they think that's going to be beneficial to African Americans. But at the same time, and I say this all the time, if I had to do law school over, I would actually join the Federalist Society.
That's right.
I would join. I would
encourage you
by
to.
The door. Right.
Look, I would have encouraged you
be
to.
The spoon. Right. Like I would have joined the Federalist Society and started taking up these originalist arguments, obviously in the favor of Freedmen and reparations for Freedmen. So I'll just stop there.
Okay. Now, thank you. Now I want to pull this up, right? This because A. Rogers, thank you for the contribution. So Supreme Court confirmed today that freedmen are former slaves and refugees were white? Question mark, question mark, question mark. Let me address that because we have to be historically grounded in this freedmen thing of ours. And people from the ADOS group, they are trying everything in their power to basically downplay this political status of our people because of course they want what they're doing to be the supreme thing, this thing that they just made up out of whole cloth to be a replacement for that status, right? And that's just what it is. So refugees, while there were some white folks who were considered refugees. There were also contraband camps. And those that know the history know that these contraband camps were converted to Freedmen's Bureau field offices because they basically served the same purpose. Those of our people called contraband who escaped from bondage went to Fort Freedom in Virginia. I always forget the name of that actual fort. I believe it's Fort Monroe, and somebody could correct me if I'm wrong on that. The legal name, and we've shown that right here on the Be the Power channel, the legal name of these, our ancestors who escaped from slavery, was also refugees. So this act also covered those people. Hence, the conversion of these contraband camps, as they were called, wasn't a legal name. Contraband was not the legal name. Refugee was. And in that, those people who were already in these camps, by the time of the ratification of the 13th Amendment, they too received benefit from the Freedmen's Bureau. Like, this is in the historical records. And this is why, as our sister said earlier, us getting to the point to where we're now writing these amicus friend of the court briefs, we have to do that moving forward. We have to. We absolutely have to, because they are confused. When I listen to Ketanji Brown Jackson, I feel as though, like we say in our camp, she's hitting at it, right? But she's not grasping the fact that Freedman is a political status. And before we play Ketanji Brown Jackson's clip, I want to pull up something that we've shared here on Be the Power. Brother Josh, shout out to BTP Josh. He said, yes, because part of the Freedmen's Bureau's work was to reunite families. That included many people who were free before the war. These are the things that we have to educate the court about. It will serve several purposes, one of which would be, we are going to stick to originalism, not necessarily in the way that Mies is trying to do it with his doctrine of color blindness that we find in a lot of right-wing ideology, but in that, these acts, these pieces of legislation, these constitutional amendments, these reconstructive amendments were designed specifically for those who had the status of freedmen in the United States of America. If we were to trace back white refugees in this country today, I'm talking about, if we were to find who their descendants were, if they're living, Abraham Lincoln has no progeny in the United States of America. Believe it or not, his progeny did not survive. So those whom are refugees, or the descendants of those refugees today, I'm willing to bet that their wealth positionality is way better than the freedmen's wealth positionality. If we were to specifically just count those whom were freed by way of the 13th Amendment, not those that were in the North already freed, right? And then those whites who were considered refugees because they wouldn't fight on the side of the Confederacy, and they also abandoned their lands. You know, the ADOS group makes a lot of bad faith arguments, and we're going to point them out every single time because that's what they do, and that is what we do. So this is from the Congressional Record, and we're going to cite, because this quote, there's a quotation that comes from the, say it again, Ali, because I always forget it. The Freedmen's Inquiry.
Oh, yeah, no. The American Freedmen's Inquiry Commission.
The American Freedmen's Inquiry Commission. There's so many different commissions that I get them confused, and it's a good thing. It's a good thing. It shows that the government was putting in the effort to make sure that we were on equal standing with other citizens. All right, so let's read this. And this, you see the source, the Congressional Record of the Senate, S10499-S10500. The most important examples involve the Freedmen's Bureau, created in 1865 as a means of providing special benefits and assistance for African Americans. The opponents of the Freedmen's Bureau Acts attacked the Bureau on the ground that it would apply to members of only one race. Right? It's the same argument. That's why we have to attack race. And while we say over here at Be the Power, we don't do race work, which is why we hardly use terms like Black or African American. The response was that discrimination was justified in the interest of equality. And here's that quote. Quote, "We need a Freedmen's Bureau," said one supporter, "not because these people are Negroes, but because they are men who have been for generations despoiled their rights." Curiously, fundamentalists don't investigate the pertinent history, but one of the explicit goals of the 14th Amendment was to provide secure constitutional grounding for the Freedmen's Bureau Acts. It is peculiar at best to think that the 14th Amendment prohibited the very types of legislation it was designed to legitimate. Voting to strike down affirmative action programs, fundamentalists have offered a hint of a reason to think that such programs are inconsistent with the original understanding. Now, I want to go back real quick. Not because these people are Negroes, but because they are men who have been for generations despoiled their rights. Someone like Meath, whom the article says was a constitutional heavyweight, and Chief Justice Roberts today was one of his understudies. Well, he would have seen this. And the article also notes that this justice had the foresight to see that, well, I know what the arguments are going to be. So let me undercut the arguments before the scholars get to them and have this as some sort of established precedent by which the right will be able to use going forward. Our problem is, as American freedmen, is that Ketanji Brown Jackson and all of her, constitutionality and her studies, et cetera, she doesn't know what we know. She doesn't know what we know. And moving forward, I think that we need to be more involved. And I'm glad our sister Kamilah is on tonight, because our sister is an attorney. We've linked up with other attorneys who understand this Freedman thing, and we're starting to grow out now. We're starting to grow out, and we definitely want to provide amicuses in cases like this, because we don't think that these people have a full understanding. So I want to go to my sister Kamilah, and then Brother Ali and Josh. Y'all come in, and then we'll play the clip.
Thank you. What you just said just reminded me of this quick comment that I wanted to provide. And I think a key word that we need to keep in mind is, or key term is, interest convergence. Like in this, fight for reparations, in the event that, amicus curiae brief is filed, in terms of effective strategy, we always have to keep in mind interest convergence and think about how do we take on the arguments from both sides, the best arguments from both sides, that obviously fit where we want to go. So, like, for instance, we know we can take, some of the gems from obviously Sotomayor and Ketanji Brown Jackson, and we can discard, the points that they're making that seem to be a bit convoluted, right? This is something that we talked about before. But with, the conservative arguments, again, we need to, take on their originalist viewpoint as much as we can, while like, as you said, Naheem, kind of discarding the kind of color blindness, kind of white supremacist way that they go about it. And so just to cite the article again, as I was rereading it, what Mies is saying when he said, although the term freedmen referred to former slaves and virtually all former slaves were Black, the triggering characteristic for receipt of government assistance was not skin color alone. By its terms, the Freedmen's Bureau Act did not help African Americans who were not enslaved before the Civil War. Okay, we can take that argument, apply it to today in favor of, a lineage-based reparations model and say, by its terms, lineage-based reparations model, and we're already ahead of the game because we're already saying this, is not race-based because assistance to African Americans is not based on skin color alone, because by its terms, it's going to exclude Black people who are immigrants, or come from different countries. You know what I'm trying to say? So just generally speaking, which I think
absolutely.
we're already doing, is like picking up on the interest convergence and compiling the best arguments from both sides to create a super argument of sorts that obviously supports where we want to go.
See, I love smart people because interest convergence. I had to look that up while our sister was going in. And that's exactly what I was implying, that we're going to take the best, eat the meat, spit out the bones from both of these sides and help strengthen our argument. That's why I keep using the term double-edged sword. And somebody said on a tweet earlier, yeah, but some of the things that she said in the past were problematic. Talk about Ketanji Brown Jackson. I said, yeah, but this stuff that she's doing now is going to help us moving forward in the future, right? We got to start taking our emotionalism out of these things and look at them through a more refined legal eye. So, Brother Ali and Josh, y'all have anything to add?
You can let Josh go in if he has anything.
Go ahead, Ali. I still got some background noise.
Oh, well, I'm so glad our sister brought up interest convergence, because that's the same thing I was thinking as I was listening to both sides. I'm like, yeah, we have to take from both sides. And I think, to be honest with you, that's what we've kind of been doing at this point, even with our moving towards opening up and having dialogues with our conservative brothers and sisters. It's like we're trying to really incorporate interest convergence, man. Like, just really trying to be that and demonstrate that and lead by example, using that kind of ideology. It's like, look, we have to use the best of both from either side of this particular thing, because that's just where we are with it. Because our interest really, it transcends both of those things, and we have to really be able to use the best from either thing to be able to move forward. And so I agree 100%. That's something that we need to do, even with the crafting of legal arguments and our quest for justice.
Absolutely. Brother Josh, you wanted to add on to that?
Yeah, I just want to say, man, thank you, Sister Kamilah, for participating and jumping on, and we are honored to have you on our program. And thank you. First off, shout out to you for everything you've been doing for the cause out in California. It's really remarkable what you guys have been able to do, the hurdles that you've been able to overcome, and I'm sure you gained valuable lessons learned that are going to help us in the larger fight.
Don't forget the haters that she's had to ignore.
Yeah, I'm just including them in the lessons learned. I don't even want to give them too much attention.
I'm just trying to, start a little mess. That's all. Go ahead, bro. Go ahead, bro.
Yeah. So, when I hear, I love it when they invoke this Reconstruction history, because that's what all this stuff is rooted in. Today's because they haven't corrected the errors of the past and the hatred of the past and the damages done in the past, it's always going to come back to you and be relevant today. It's just like you think that you can't, if you got problems in your house, or if you're driving around in a car that, you know, I don't think they do this anymore, but people used to get the old hoopties, the old beat up Caprice, and all of those. What are the other joints that we used to ride in? Put the TVs in it. Yeah, I know them old
That's
cars.
funny. You said TVs.
Yeah, you know, put the TVs, put the rims on it, get the paint looking nice, and then but you know it ain't a new engine in there, so you know you're gonna still be having problems. That ride don't really ride too well until you do like the real important replacement stuff. So you can try to repackage our people. You can try to give us the image of hip hop. You can try to give us the image of all these other things. You didn't repair the damage that was done through the generations of slavery, reneging on Reconstruction, black codes, Jim Crow laws, mass incarceration, the crack era, all this type of stuff, and now mass immigration. You know, you didn't repair the damage that was done. So now you can't move forward in anything civil rights without this Reconstruction time period rearing its ugly head and throwing a monkey wrench into everything other groups are trying to do. You know, I love that she's once again sticking the Freedman history and interjecting that on today's fights, because that shows you that is the foundational fight in civil rights. We created the civil rights over here through first off survival, you know, at genocidal attempts. You know,
That's
we created it through survival. Our people had to survive over here first. Then we had to have bravery and valor to fight to get up out of that institution, you know, um, and statesmanship. I mean, imagine the people coming out of slavery and now you have people becoming statesmen. You got people becoming governors, senators, Congress members, state senators. You know what I mean? Through all levels of government. Then you had the people, we had to go back and be survivors again. We had to be inventors. We had to be innovators. We had to be creative. You know, we had to do so much throughout the generations. And just to finally get a victory in the 60s where you get the government to concede and say, you know what, we really got to do some real civil rights stuff because what's going on here, it's a national security risk. You know, you got Russia or the Soviets, that communist stuff gonna win, and you know we're gonna have another civil war here. This country's gonna break. We have to do civil rights. Oh, okay, we'll concede on that. And now the little bit of gains that were had, well, we didn't even get the majority benefit. You have groups that are trying to eliminate that we fought to help come over and create the civil rights for. You want to eliminate affirmative action and try to act like the freedmen don't matter. We didn't have no history in this thing. We didn't build this thing. Weren't the engine in the thing.
Let me just say real quick, because that's another thing that I want us to kind of talk about later, Josh.
Okay.
Affirmative action, right? It's not what it was intended to be. Do we scrap it or do we modify it? You know, there's some talk about that. I've seen, shout out to brother Tony Blunt out of New York. And you know, he came on my thread and on a tweet, and he basically said that. You know, he's like, I'm out of, you know, it's not being used for us. So I'm of the mind that I don't know. And I'm like, yeah, I feel the same exact way. So let's just play this clip from Ketanji Brown Jackson. Let's get into this.
Oh yeah.
And then just let's round out this discussion, because I want, this is like really what she said is, to me, is the purpose of tonight's stream, right? This piece right here. And that's why I named it Affirmative Action, Freedmen, and the Supreme Court. I should have threw the 14th Amendment in the title. Man, did I do the hold on, y'all. One second, family. 1 second. Share audio. Okay, I think this is it. Okay, there you go. All right, so let's play this clip and let's let this discussion play out from here.
And so what I'm worried about is that the rule that you're advocating, that in the context of a holistic review process, a university can take into account and value all of the other background and personal characteristics of other applicants, but they can't value race. What I'm worried about is that that seems to me to have the potential of causing more of an equal protection problem than it's actually solving. And the reason why I get to that possible conclusion is thinking about two applicants who would like to have their family backgrounds credited in this applications process, and I'm hoping to get your reaction to this hypothetical. The first applicant says, I'm from North Carolina. My family has been in this area for generations, since before the Civil War, and I would like you to know that I will be the 5th generation to graduate from the University of North Carolina. I now have that opportunity to do that, and given my family background, it's important to me that I get to attend this university. I want to honor my family's legacy by going to this school. The second applicant says, I'm from North Carolina. My family's been in this area for generations, since before the Civil War, but they were slaves and never had a chance to attend this venerable institution. As an African American, I now have that opportunity, and given my family background, it's important to me to attend this university. I want to honor my family legacy by going to this school. Now, as I understand your no race conscious admissions rule, these two applicants would have a dramatically different opportunity to tell their family stories and to have them count. The first applicant would be able to have his family background considered and valued by the institution as part of its consideration of whether or not to admit him, while the second one wouldn't be able to, because his story is in many ways bound up with his race and with the race of his ancestors. So I want to know, based on how your rule would likely play out in scenarios like that, why excluding consideration of race in a situation in which the person is not saying that his race is something that has impacted him in a negative way. He just wants to have it honored, just like the other person has their personal background, family story honored. Why is telling him no not an equal protection violation? And so what I'm
You're on mute, bro.
Yeah, you on me.
Jeez, my bad. we see. I'm gonna put that link in the chat. I wanna start with you. Did you want to go on that, Ali?
Yeah.
All right, go ahead. And then I want to go to Sister Kamilah and then Brother Josh, because that is the thing that kind of got me wanting to do tonight's live stream. That right there. And just real quick before you go in, because I was looking at some of the commentary behind these exchanges, right? And the attorney's name was Strawbridge. And his response was basically about all of the races being treated equally. And, many people said that it showed the weakness of the position of those who are trying to oppose affirmative action. So what is your take? And then we're going to go to Sister Kamilah.
Yeah, I mean, I have the same take on it. The positions are weak. But the thing that that this brought to mind is this: like, look, we're more interested, like for the people who have heard us say we're not interested in doing race work, right? There's a reason, right? One of the main reasons is, in essence, I would like to take the path of least resistance, right? So for me, I understand that race is a problem for them, even though, like I said, they imposed it on us. They don't want us to use it as the grounds upon which we're seeking remedy, right? They don't want you to be able to use that to seek remedy, even though they forced it on you and the consequences of it. The problem for me is getting caught up in doing race work. I really don't want to do that. I would rather take what appears to me to be the path of least resistance, which is to deal with us by population group, ethnicity, if you will, but population group, as opposed to race, population group, and those people who are the population group being the injured party, if you will, those people who were forced to endure the oppression and the abuses and mistreatment inside of this country by way of public and private practices, right? Uh, so that's my thing about it, right? I would rather choose, well, like I said, what appears to me to be the path of least resistance, which is to move away from race, if possible, right? However, they aren't going to let us do it, because one of the things that I saw was the terminology descendant of slaves, right? The descendants of slaves, and how they would respond to using terms like descendants of slaves. And one of the things that they showed me is that what they'll do is they'll say that the terminology descendants of slaves is really a proxy for race. And so I think that, like I said earlier, what we're dealing with is a battle of words, a battle of words, how we're using these words, uh, contextualizing it within history, within rooting it in the Reconstruction history and the legislative intent, particularly of the radical Republicans at the time. And I think we have to really, really dig. This is what it's showing me. We're going to have to really dig into what these guys were intending when they were addressing the problems of the time, particularly in the South and in the United States and a whole, and try to move this country forward. But I think that's what we're going to have to do. We're going to have to really start digging into these congressional records and these congressional debates to see where these people's minds was to prepare the arguments so that we can properly address these people. But again, like I said, I agree that the positions are actually weak. They've been weak from the time of Reconstruction, since we see they've been arguing these same things from that time period.
So before we go to Sister Kamilah, I want to pull up 42 Tribes' comment. Calling descendants of slaves a proxy for race is racist. What is your response to that, Ali?
Well, I mean, yeah, I would agree with that. I think that that's true. It is racist, right? Because basically what these people are saying to us, is that I really don't, let me just say, we really don't give a fuck about what you're talking about. Everything that you come with, we're going to try to equate it right back to race. Doesn't matter if we imposed race on you. It doesn't matter if you're trying to move away from it. We'll use tricknology, we'll use trick language and say, and even though we're admitting that the terminology descendant of slaves is not a racial term, by calling it a proxy for race, we're admitting that it's not a racial term, but we're going to use shit like that just to fuck with you, just to try to stop you from actually getting the remedy, getting the justice that you so desperately need and deserve.
That you are owed.
That's right. That's right. So, all right. So, Sister Kamilah, go in on the clip first, and if you want to respond to the proxy for race thing, be my guest.
Yeah, so essentially in the clip, what I took from it was that Justice Ketanji Brown Jackson was eloquently making the argument that, and I'm just using this term, African Americans are another type of legacy student. So traditionally at these elite universities and Ivy Leagues, you have what is called legacy admissions. And actually a sizable number of white people who attend these universities actually got in via legacy admission. So that means their father went to Harvard, their father's father, essentially they have ancestry,
That's
tied
right.
into these educational institutions. And so Justice Ketanji Brown Jackson, in the words of Chairman Fred Hampton, was heightening the contradictions when she said, how is it not an equal protection violation of the 14th Amendment to say, okay, we can consider the white legacy's students' ancestry in terms of how his family has been connected to this institution for generations, but then we say it's not allowed for the African Americans' family history to be honored in that way as well. How is that not an equal protection violation? You're treating two different people differently, right? Similarly situated people at that, because in both instances ancestry is implicated. It's just in the white case, it's tied up in privilege, and in the African Americans case, it's tied up into slavery and subjugation. So what are you really saying? That doesn't matter, that should be disregarded? And on what basis is essentially what she was trying to draw out. And to Naheem's point, what she was really doing was making the case for Freedman as a political status, but she was using terms of race to kind of describe it. And that might just be kind of a limitation of her not really understanding the distinctions, or maybe that's just what she believes, that this is firmly rooted in race. We don't really know. But I just think that was a really good comment of hers, for her to kind of heighten the contradictions and show kind of the hypocrisy, and to Ali's point, how it really is truly a battle of words. The other thing I just wanted to quickly say was to the point of, okay, broadly, should we get rid of affirmative action? I think many people in the reparations space think that we should get rid of affirmative action because, again, it's not benefiting the people that it was intended to benefit. And so let's say we get rid of it, that's fine. Now I'm just thinking ahead. What would be next? Do we carve out, I think, as Ketanji Brown Jackson was saying, another type of legacy admissions that is separate and apart from affirmative action, because it would be gone at that rate? But then at the same time, and I'll conclude by saying this, it's the kind of schizophrenia of white conservatism in this country, because on one hand, you have people like Meese and other people who were arguing on
Yeah, did she go out, or is that me? Can
you hear me?
Okay,
We
there
can hear
you
you
go. There
now.
you go. You had went out
Sorry,
for a
I got
second.
a call.
Mhm.
The last thing I'll just say is this: I think we can get rid of affirmative action, and I argue that might be the best course of action. But at the same time, we have to keep in mind kind of the schizophrenia of white conservatism, which I think bore out today in the petitioners' arguments. Because on one hand, they were saying, the Strawbridge was saying, oh, the Freedmen's Bureau and the programs that came out of that were sufficiently, they were race neutral. It was nearly tailored to to meet a compelling government interest. But then at another time, they were the same people, the same side, the petitioners who were trying to destroy affirmative action, were saying, when Kavanaugh asked, isn't descendants of slaves race neutral? Oh, could we give a benefit to descendants of slaves? they were saying, oh, no, you couldn't do that because that's a violation of the 14th Amendment because it's considering ancestry. So it's like, which one is it? You know what I'm saying?
Right.
So it's like that's kind of what I'm grappling with. Okay, well, let's say we get rid of affirmative action and we try to, you know, create some legacy admission standard that's narrowly tailored to remediate African Americans who are descendants of slaves. Who's to say and what's to stop someone from saying, oh, that's not allowed because that's the equal protection violation that is that wrongly considers ancestry. And the last thing I'll say to this, and which is crazy, again, that bore out by the petitioner's arguments. They were saying a benefit cannot be derived to descendants of slaves because of that ancestry component, but it can be derived to children of immigrants. Well, why is that? Because if you're considering children of immigrants, that's still implying ancestry in a way. You're deriving benefits of immigrants. Immigrants are people who have ancestry elsewhere. There's still a conversation around ancestry looped into immigrants, right? That's kind of baked into what an immigrant is. It's a person who moves from one place to another, from another place and comes to another. Ancestry is inextricably woven in conversations of immigration or immigrants, excuse me. So again, there's also some type of kind of contradiction between the conservative arguments in terms of, okay, a benefit to children of immigrants is okay, but not to descendants of slaves.
And now, peep this, sis. This is crazy, right? Because in that particular exchange where he was talking about the descendants of slaves, basically, it would be a violation of the Constitution, right? By trying to have them benefit from the 14th Amendment, which obviously is a part of the Constitution. The crazy thing about it is we were talking earlier about the preamble. Remember, Brother Naheem, we were talking about the preamble and the fact that the preamble says that this Constitution was established for the benefit of not just those people, but the progeny of the people. So I'm like, what's really interesting is that what they're talking about actually is in contradiction to what the preamble sets out in the very outstart of the Constitution itself, mentioning the progeny and the benefit of the progeny moving forward. So it's just insane that they can come up with these kinds of arguments where they would actually say something like, the descendants who are the progeny of those slaves somehow should not benefit from the Constitution.
Now, my conclusion today, and I didn't listen to everything. I listened to several excerpts. I've read several pieces. Somebody had a long running tweet on a lot of the points that were brought up during these hearings, if you will. This, I don't know. I guess we can call it a hearing, but it's really litigation, and our destiny and our future is at hand and at stake here, I should say. And it brought me to this question. Is this a white man's country? Simple question, right? Let's go back. Let's look at, so Kavanaugh asked this question. What about a college giving a plus to descendants of slaves? Would that be okay? The attorney Strawbridge said no. Kavanaugh asked, what about a plus to students whose parents are immigrants? Strawbridge said yes. Now remember, this is a white man. From the right. Kagan asked, when colleges apply gender neutral principles, they get far more women than men. Could a university put a thumb on the scales and say it's important that men receive college educations? Strawbridge responded, yeah, that's fine. Kagan then said, Isn't it weird that white men could get a thumb on a scale, but not people who have been kicked in the teeth? Strawbridge's response was not white men, just men. So color blindness becomes this cudgel. It becomes weaponized, right? And what's masked here is this question that I asked. Is this just the white man's country? And they get to decide who is going to be full citizens in this country or not. Because all of these questions, I want to go back to what Kavanaugh asked. What about a college giving a plus to descendants of slaves? Would that be okay? No. Now, these slaves are the very people that built the economic foundations of this country, made it the most powerful country that this world has ever seen. Kavanaugh asked Strawbridge again, what about a plus to students whose parents are immigrants? And this guy's response is yes. These new people, go back to MLK's lecture that we're coming to get our check, when he spoke about us being denied our rightful place in America by having land, and how the United States of America gave away millions of acres to undergird its white peasants that were coming from Europe. This ideology that they have, it's a long thread that runs from Reconstruction, and it is centered in the hatred for the American freedmen, which Ketanji Brown Jackson cited last month.
I was just getting ready to bring that up, man.
The hated freedmen. They hate us, family. So there are several questions moving forward. And Josh, I want you to jump in, but there are several questions moving forward. And I don't think that the questions are being asked properly. And maybe my opinion is just off. But whether I was a legal mind or not, listening to all of this made me ask the question, is this a white man's country? And do they, the people who called themselves white, because nobody's white, just like nobody's black, just like nobody's red, just like nobody's yellow. The people that called themselves white in this country, do they get to decide who can be full citizens in this country? Because it appears to be that way. 1866 Civil Rights Act. Well, in order to in order to solidify the 1866 Civil Rights Act so that another Congress can't come along and unravel it, we're going to enshrine it constitutionally with an amendment, the 14th Amendment. Okay, the 1875 Civil Rights Act. This is 3 years after the Freedmen's Bureau is shut down. And what happens? A few years later, in 1883, the Supreme Court rules that the Civil Rights Act of 1875 is unconstitutional. Why? Because there's no constitutional amendment that upholds it in the same way that there's a constitutional amendment that upholds the 1866 Civil Rights Act. And from 1883 to 1965, there was legal discrimination in this land due to the fact that the 1866 Civil Rights Act was ignored, that the 13th Amendment was ignored, that the badges and incidents of slavery that the 13th Amendment was supposed to eradicate in the first place were allowed to be placed upon us. What's that term, Ali? Macula servitutis, the stain of slavery. We wear it to this day. It is in our visage, the color of our our embrowned visages. We have to start asking these questions in a more roundabout way. Is this a white man's country? And I think we need to make the courts prove that. I don't care if it's a conservative leaning court. That's my take on the matter. Brother Josh, go in, and I would like to hear everybody else's, response to my question.
Man, I gotta say that Kavanaugh response, you know what I'm gonna say. You go ahead, finish my words. You know what I'm gonna say.
I mean, there's many things that we say.
It's one word though. Start with an R.
No, go ahead. Bro.
Oh, that replace your word.
Replace your.
It's replace.
Now, if you would have said my new word, I would have known exactly what you're talking about.
Oh yeah. Hashtag replace your RAP.
That's right.
I mean, excuse me. Damn, not RAP. REPLASURE. Replacer is a conjunction of replacement and erasure, and that's really
what's the fancy word for it? Portmanteau or something like that.
Yeah, portmanteau. Yeah,
portmanteau. I always say that wrong.
Yeah. It's pretty much, man. Like, damn, man. Freedmen, what he meant to say, freedmen, descendant slaves. No, immigrants. Yes. That it just tells you what the agenda is. That just tells you that at the heart of this thing is, look, the freedmen are people who demand justice, equal protection, equal rights in America, equality. We demand that's the stuff that we're about. That's what we've been about. We got up off the chains and we got civil rights legislation put on the books. We were no longer the group to be exploited on a large scale. You're not going to exploit us for on the wage labor. We're not going to exploit us on none of that. So what they see is both on the high end and low end of labor, we want to replace you with somebody else who we can exploit, because you're not the one that's going to stand for exploitation. And we damn sure don't want you being over in the equity ownership class with us, understanding the game and all of that. So, I mean, I look, man, some of the stuff may not be necessarily PC or whatever, but that he's telling you what it is. He's telling you that and just like we see in a lot of these deep South states, to their own detriment, they'll be anti-freedmen. Never mind that, you look at the wealth levels of some other groups and you see that they supersede white wealth at the median, and on average. Never mind that, the hated freedmen, we're going to continue that ideology at the highest levels of government. And even though that type of ideology of putting everybody else above the freedmen will cost even the white folks in America, like that, and the existing immigrants in America, like that is that's really telling something, man. And I don't know what to say, except just have to be aware of this agenda of replacer. It's really disheartening, but what do? All we know how to do is fight. So we're gonna continue to fight. When I look at the affirmative action question, I know we keep talking about it and hitting at it and say we're gonna talk about it, but let's talk about it. I look at it as this: like, that was a victory. That was a victory that was claimed by our people. It took a whole lot to get to that. Yes, other people, it was exploited, but it's kind of like saying, well, we look at post-integration and that was getting integration was a win, but we look at it as like, well, it's been our situation has been negative after that. Let's go back and put segregation back on the books. I would say no. Keep affirmative action. We need affirmative action reform. That's what we need. We need it to work and be reinstated instituted or redefined to carry out the original intent. The original intent of affirmative action was not to let white women subvert the original intent. Well, the original intent of affirmative action was not to you know, because essentially it's still buoying and boosting white families, the white women who were married to white men. It was original intent of affirmative action was not necessarily to have elite immigrants come and be able to feel like that they have some type of special right to claim something over even white people who are here. Like, I don't understand how a person can come to America and receive citizenship or receive residency and be able to work and make high wages and live a lifestyle, and they be able to send a large amount of money relative to the country they're coming from. And then you feel like that you are supposed to be even more privileged than some of the white people that even built America. Like, I mean, this is not me taking up for white people. I'm just trying to understand what in the world are these white folks thinking by boosting up that particular position. And so the original intent of affirmative action was America knew that the freedmen owed a debt. You knew the dirt and the evil that was put on the freedmen for generations, and even before we were freedmen. So they knew that, and it just like Lyndon B. Johnson, President Johnson, said at that Howard University speech. And I don't want to quote him because I don't even have the quote in my head, but he even outlined that basically, how in the world is it fair and right that you have held a people back for so long, and now you think you're supposed to just, all right, well, go ahead, let's go at it, knowing that there's still institutional discrimination going on. Even though you can outlaw it, you still got to enforce it, and it's embedded through the generations. And how in the world people got such a huge head start, and you telling them now go and compete? You have to do something to make it to where they can have an opportunity, and where you make it happen. Like, you don't just tell them, you don't just say corporations, okay, yeah, you gotta include them. No, we do affirmative action. And so that's what it was for. It didn't, like, you can't say that groups that weren't even here were held back. How were you held back here when you weren't even here? How can you say, and I'm not, look, a white woman was held back when, okay, you can make an argument for that, but she was still a part of a white family. She had a white daddy, white husband, brother, sons, and all that kind of stuff. And when she owns it, let me just call it out. It's a lot of fraud going on. It's people frauding that game where people get access to things in name only, but really it's the same people that are using the set asides that were meant for the freedmen to be able to take advantage of it. That's just how the game is working. You can I have many friends, and I brought this up many times before, who work on projects in different cities. I'm in the DMV area, so Baltimore and DC, that when certain set asides are put, is not race specific, but they use certain blanket terminologies like minority disadvantage and all of that. And so what they do is, the white person that got the capital, they want to get a competitive edge in the business, they go and they find a front man, that's a freedman, and they say, or there might even not even be a freedman, it might just be a black woman, or it might be somebody that's not a able-bodied straight white man, and get them to be the front person for the corporation, and then they benefit. Or it might be somebody who is an elite already from another country, and get them to be in the front of it. So look, I don't have nothing against any of them people. Like, all those people, I'm not mad at you taking advantage of what was here and done. What I'm saying is that is an injustice that's allowed to go on. So as far as affirmative action goes, no, I don't believe we should get rid of it. I believe it should be reformed. I think it should be challenged, like it's being challenged by us to make it. I think we need to be the main ones challenging, not the Asians to get rid of it, but we need to be the ones challenging affirmative action, or pressuring our Congress to change and redefine an affirmative action to do something specific for Freedmen. And maybe here's what and I'm gonna finish with this and pass it back to y'all. But I think the main thing that needs to happen that needs to be that we need to all consolidate on establishing is we need established a specific set of, in the same way like the Bureau of Indian Affairs is put in place, where it's something that's unchallenged. Nobody ever challenges the set asides that's made for Indians. They already established that they're a specific group. They have specific set asides, and that goes unchallenged. The Freedmen we have the most long-standing, the largest debt that's owed to anybody, the largest claim of atrocities and everything that's done, what was stolen from us over Indians, over every damn body. We need to have some type of specific set aside, specific that goes unchallenged. This stuff is not the amount of evidence. Look, there's a lot of Kanye talking about the Jews and all this, and they got their, atrocities that they experienced. We need to have on record, to where, like, how in the hell can you in one breath speak about the atrocities experienced by the Jews over the course of and not to diminish it, but a far shorter period of time that we experienced our Holocaust here in America. But you have the audacity to come and try to challenge some type of redress for a group that ain't never got no damn reparations, and they never got no redress. We never got no country set aside, a land. You never took no military and said, we're going to take this land and give y'all. You never did any of that. What you did was you did the opposite. You did oppression. You took essentially what equates to the Nazis and put them back and let them get back in power and let them rule over us and institute slavery by another name. So we need to have an established, whether it be new Freedmen's Bureau of Freedmen Affairs, something where this stuff doesn't need to be challenged no more, whether we get specific set asides. You know what the hell you did. You know what the hell we owed. That's what we all need to consolidate on and focus on. So I'm going to pass it back to you, bro.
Indeed. Sister Kamilah, jump in, sis.
Oh, no, I'm good for now.
All right. Brother Ali, did you want it to go in?
Yeah, just coming back. I was trying to read that piece from Thaddeus Stevens. I wanted people to see that even back then they recognized there were certain people who recognized the actual hatred and call it out for what it is, right? So right now, people won't necessarily say that in government. You're not going to get people in government who are going to say this stuff is based on hatred, right? But back then, people like Thaddeus Stevens, man, they were calling it out. So I put the tweet in the inbox. If you could pull it up, we could just read a little bit of it, because this is the actual the actual debate surrounding the 14th Amendment, and this was from Thaddeus Stevens himself. And Justice Brown Jackson used this. She actually cited this particular section. And I just wanted the people to see that this is not something that we're saying just out of the blue. Like, this is really hatred. And like I said, other people at the time recognize it for exactly what it is, hatred.
Indeed. I'm pulling it up now, but we have a question in the chat while I'm doing that. Shabazz Navarro asked, how do we get affirmative action in a way that doesn't invoke race?
Let me say something to that. This is what I wanted to really touch on too. I think people don't really understand the necessity of the usage of status. I think when we say stuff about status and Freedmen being a status, etc., that it's kind of like getting lost on some people. But I want to say that this country responds to status, right? They don't necessarily want to respond to race, right? Not particularly, not any race other than the white race, but they really don't want to respond to race. They want to, if they do race work, it'll be under the guise of status. So for instance, the race work they do for Latinos or Hispanics is under the guise of immigrant, the status of immigrant, the status of asylum seeker, okay, the status of new American, right? They don't specifically go head on and be like, we're going to do this Latino legislation. It's not that. It's like, we're going to do some stuff for DACA. You know, we're going to do this DACA thing, this Dreamer thing. We're going to do this asylum seeker thing. We're going to do this refugee thing, right? All of these things are statuses: refugee, asylum seeker, new American, immigrant. All right. Same thing with any other aspect of this society that you look at. Really, what they're doing is they're dealing with status. Like when we say refugee, that was one of the statuses from back in the Reconstruction period. The Bureau of Refugees, Freedmen, and Abandoned Land. So they're dealing with two different people with two different statuses. One had the status of refugee, another had the status of freedman. So they're responding to statuses, and they're enacting legislation based on the status that people occupy in society, right? So it's like, citizen, right? And, is a status. That's a status in society, citizen. So they respond based on the status that people occupy. If you're a husband, if you're a married couple, right? Being married is a status, right? So you have certain benefits filing jointly, right? When you this is what I mean, like this, everything that this government does is in response to the status that people occupy in society. They don't want to really deal with race like that. Man, in fact, like I said, if they do deal with race, it's under the guise of some status that the people of a particular race is occupying. And so I think when it comes to the issue of affirmative action, even as we're looking at reparative justice, like I said earlier, the path of least resistance to me is to avoid the issue and the topic of race at all costs, right? To try to move away from that, other than to show that race was used as a tool of oppression, but not necessarily to use it for the specific purpose of identifying an injured party group. Like, I don't think we should do that. I think we should really use and try to master the usage of status in this society so that we can get the type of response that we need, because we already know if we're using race, what they're going to say, even with the status thing. Because we've seen what they said about descending of slaves, trying to say that it's a proxy, so we can kind of get an idea of what's down the pipe, right? We kind of know what kind of arguments they're going to raise. But I think, to me, like I said, the path of least resistance is to move away from race, move away from that conversation, and move more into this is our status in this society. The same way that the Indian freedmen, the Chickasaw freedmen, the Choctaw freedmen, the Seminole freedmen in society, that they still use that, and they use that status. It's not only like us, they use that status for the purpose of trying to achieve justice from those tribes.
Hey, let me just jump in real quick, Ali, because I'm gonna ask you a question. So there's a Bureau of Indian Affairs. How come? I know it's different because you're dealing with sovereign nations and all that kind of stuff, quasi sovereign nations. But why is it that nobody looks at that as a violation of the Constitution, because that's discrimination based on race, and being that those people are still American citizens?
That's an excellent question. Maybe Sister Kamilah has some insight on that. And that's an excellent question, bro. What would you say, sis, on that? I mean, I think you kind of touched on it, Josh, in the sense that they are quasi or sovereign nations, even though the members of those nations have been made citizens of the United States by the Indian Citizenship Act in 1924, I believe it was. But I do think that sovereign status or quasi-sovereign status plays somewhat of a role in how the United States government interacts with them as a nation of people. Yeah, they're dependent nations, but I think the quasi-sovereign status has some role in it. Again, I don't know, but maybe, like I said, Sister Kamilah has some insight on that if she's
Hey, brother Josh,
yeah,
repeat
go
the
ahead.
question, bro.
So my question was, we have a Bureau of Indian Affairs. Now, Indian is considered, according to Directive 15, it's considered a race. It's not considered um, some other kind of status, right? Now, maybe you can say their status as a quasi-sovereign nation, um, various members of different tribes, has something to do with it not being a violation of, civil rights law. But essentially, Indian is a race, is a racial category. And I don't hear anybody saying that budget allocations to the tunes of billions of dollars or tens of billions or hundreds of billions over the course of years is racial discrimination. Nobody goes and argues with them on that. So why is that, and why does that only apply to us?
Oh, well, yeah. It's interestingly enough, when I was in law school, I was definitely in the Black Law Student Association, but I was also on the board of the Native American Law Student Association. And I also participated in like a tribal law moot court. Not because I'm not Native American, but I kind of just wanted to see what the similarities and differences were between African Americans and Native Americans, just to see how that could be utilized in the reparations movement. And so what I learned is basically what you all stated, well, what Ali stated, in that Native Americans, they're considered domestic dependent nations, while simultaneously they're also considered sovereign. So they can, that's only if, also the caveat, if they are federally recognized. So if you're a federally recognized tribe, you are considered a sovereign nation. So many people don't know there are many different nations within the larger nation of the United States that exist today. Those nations belong to federally recognized Native American tribes. While they are sovereign to certain extents, right? For instance, they can police themselves. There's a whole case in the Supreme Court right now around that. But by and large, these federally recognized tribes can police themselves. Let's say, for instance, a Native American commits a crime outside of tribal land. That's what's being argued in the Supreme Court right now. Does, for instance, the state of Oklahoma have the authority to keep that Native person, or must they return that person to Native authorities? Right? It's this underlying tension that has existed since colonization in this country between Native Americans as sovereign nations and the United States. Well, at the same time, as Ali stated, they are dependent on the United States for a variety of different things. And so African Americans, like our experience is, I learned, fundamentally different in terms of like what we're asking. By and large, when you study kind of like African American history, we definitely have demanded like our own nation within a nation. But for the most part, we have argued for us to be included within the larger body politic of the United States. And so that's why we have the 13th and 14th and 15th Amendment that was, enshrined in our Constitution to affirm our rights as American citizens. Whereas, Native Americans, as Naheem stated, many of them are also American citizens. They still retain their sovereignty. What I wanted to say is, for instance, the state of California, well, the University of California, just this year, they adopted a program to provide free college tuition to members of federally recognized tribes. So if you're a part of a federally recognized tribe, now you can go to any of the over 9 colleges within the UC system for free. And so one of the it was in an article that described this program. I'm going to try to find it for the audience. People were wondering, well, how is that possible? Isn't Native American a race? And so then in the article they responded, well, no, members of Native, a federally recognized tribe, it's a political status. It's not a race.
That's
and so
interesting.
that's what justified that program to exist. So I'll try to find the exact article.
But see,
real quick,
Josh, you see how flexible race is, right? Something or someone can be race or racialized or racial at the whim of the powers that be. No. They're not a race. They're not a race. I'm sorry, but you Negroes, you're a race, and you're not going to get any of this farm bill. This COVID relief money that specifically would go to Black farmers. We're going to make sure that you don't get it. And those other groups, those disadvantaged groups, as the claim says, as the bill says, they'll be able to get it by simply skirting around those means. But you Negroes, you Black folks, nah, you're a race, and we're not going to do anything specific for you all. It brings me back to the question. My bad, Josh, but it's bringing me back to the question.
I just had a statement. I ain't gonna take it nowhere else. Well, go ahead.
No, go ahead, bro. It just brings me back.
Yeah. So basically they said we need a Bureau of Indian Affairs, or we need free college for Indians, not because these people are Indians, but because they are men who for generations their land was stolen, et cetera, et cetera.
Talk to him, Josh. Talk to him, bro. Talk to him. That's what they said in the congressional record, right? But the only thing is we don't at the I'm gonna butcher the name again, the Freedmen's Bureau Inquiry Commission, etc. I made
the American Freedmen's Inquiry Commission.
The American Freedmen's Inquiry Commission. I don't know why I can't just memorize that, but I want to read that again, right? We need a Freedmen's Bureau, said one supporter, quote, not because these people are Negroes, but because they are men who have been for generations despoiled their rights. That's what this thing
right
is.
now. Right.
Naheem, did you read the spoil already?
No, he didn't give the definition.
Yeah, you need to do that.
But
go ahead, Ali.
That description of men who have been for generations despoiled their rights is describing a status. The status was called slave.
That's right. That's right.
And so they were responding to the slave status with legislation.
That's right.
You see what I'm saying? That's what I mean when I say they respond to statuses. Like they're not going to this race like people be talking about. We need an anti-Black crime bill. Like, okay, well, Black is a racial classification. And if you think you're going to get them to do that, you're sadly mistaken. And they're not going to do that.
That's right. The spoil means steal or violently remove valuable or attractive possessions from, plunder. Look at the 13th Amendment, right? In conjunction with the Freedmen's Savings and Trust Bank.
Ooh, that boy Thaddeus Stevens was spitting back in the day, wasn't he?
Plunder. Many historians say that bank was plundered. Violently remove is another of the meanings of the spoil. When we attained office, Wilmington, North Carolina, for instance, that is the highlight of political domestic terrorism. Our people were violently removed from the process. Our ballots, our suffrage rights were valuable. That sacred ballot is what it was called in our previous school of thought. That valuable thing was suppressed. And when they passed legislation to ensure that we would go to the polls and vote equally, states adopted rules by which Oh, Negroes can't read. Let's do a literacy test. Count how many, what was it? What was one of them? How many
Grains of sand in
grains
an
of
hourglass.
sand? Devils.
Sister
so-
Kamilah. Oh, go
Mm.
ahead. Go ahead.
Go ahead,
No,
Charles.
I was gonna
Oh
say,
no, I
sister.
didn't mean to cut you off. Sorry.
No, I was gonna ask because you out in California, y'all went in, man. Y'all had a in-depth report, and I just wanted to see if you could even just speak to some of the examples of how our rights have been despoiled, and some of the most egregious, examples. If you can highlight maybe a few.
But real quick, I know you want to do a follow-up to the Native American thing. So you can get into that and then just kind of come back into the despoiled rights aspect.
Yeah, my only follow-up was to Josh's point. Native American is a race. It is a race. And to the point about the UC system program, in order for that program to exist, it had to circumvent Proposition 209, which is the law on the books of California that bans the consideration of race in terms of public education, employment, and contracting. So this UC program that gives free tuition to Native Americans is not to all Native Americans. It's only to Native Americans who belong to federally recognized tribes. And so a lot of Native Americans are upset about this because they're like, what about me? I'm not a part of a federally recognized tribe. But they have to be left out. And they're adopting to, go on with this restrictive kind of approach, similar to what the California Reparations Task Force is doing. We are operating under Proposition 209, which bans racial classifications in education, contracting, and employment. And, other than obviously the moral and ethical considerations for why lineage-based reparations is important, we also have to think about the legal landscape. And so, the fact that Proposition 209 is still a law is just another added reason why, we have to exclude Black immigrants from, this reparations plan. So I just wanted to do a quick follow-up with Josh and to affirm what he was saying. Yes, Native American is a race. But I guess federally recognized tribes, I guess it's not necessarily a race, it's a political status. And, that involves, non-federally recognized tribes not being able to benefit from that free tuition program.
So what you're saying is we need federally recognized lineages or something. Where
yeah, and that's something I've
families,
argued.
yeah. Well,
we
where our
need
families
to get there. We
Yes,
need federal recognition sooner rather than later.
Mhm.
I even argue if we can get the U.S. government, Congress, even Biden, to recognize freedmen as a political status before, let's say, the task force sunsets in July of next year, that would be outstanding because that would just further solidify kind of where we're going. If state reparations task force continue to prop up, but then obviously, of course, for a federal push, I think federal recognition of freedmen as a political status needs to happen like yesterday.
Yeah, because the lineages of the Freedman family are old. It's not because we are Negro. So you can throw race out of the window. Talking about descendant of slaves as a proxy of for race. No, just because everybody falls under one category doesn't make any difference. The same way, just because all the federally recognized tribes fall under the racial category of Indian, that's not a, you can't say, well, that's just a proxy for race because these federally recognized tribes. No, it's a specific set of people who the federal government recognizes that, okay, we know some certain things were done, damage was done, and we need to have some type of recompense. So we're gonna put some specific set asides for you, only for you, that we recognize. Not everybody else that pop up and say they're Indian and they're part of some racial group. No. So I would use I mean, it seems like to me, anytime when, that proxy for race crap comes up, just point to the Indians. No, we can point to the American Freedmen Inquiry Commission. We can point to the Indians. That's not, you can't say the federally recognized tribes are a proxy for race, right? I mean, does that make sense, sis? I mean, do you agree with that?
Yeah, that makes perfect sense. Definitely. I definitely agree. And I'll just clarify by saying, when I said, oh, we need the federal government to recognize Freedman's political status, I guess that's already happened, right?
Yes. Yeah. I was
There's
going to say
history
that.
to support that.
That's right.
So it's just kind of a re-recognition.
That's
in a
it.
sense.
And I think that with the court cases that are coming up, like all of this stuff helps us. Going back to Clarence Thomas, you couching his, his dicta, right? In the Second Amendment case in New York, in the fact that freedmen were given this right to bear arms because we were in fact recognized as citizens who did receive special protections from this government. This is what all of the acts and I just got a bunch of this stuff in front of me right now. And this is what the legislation was about. This is what it was about, to create a protected class. When you look at the Civil Rights Act of 1866, right? Let me see. Do I have that pulled up? Okay. So the last paragraph of part of section 1. Let me see. I'm gonna just start from here. To sue, or to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws, and be subject to like punishment, pains, and penalties, and I'll skip the line, and proceedings for the security of person and property as is enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties, and to no other, any law, statute, ordinance, regulation, or custom to the contrary notwithstanding. There's ways for us to look at this provision, this section, where there's a distinction being made, where it says, as is enjoyed by white citizens, right? And I got to pull this book back up. I got to pull the white by law back up. And the author says this: in short, the courts were responsible for deciding not only who was white, but why someone was white. This is on page 2, white lines. How did the courts define who was white? What reason did they offer? And what do those rationales tell us about the nature of whiteness? What do the cases reveal about the legal construction of race, about the ways in which the operation of law creates and maintains the social knowledge of racial difference? Do these cases also afford insights into white racial identity as it exists today? What finally is white? In this book, I examine these and related questions, offering a general theory of the legal construction of race and exploring contemporary white identity. I conclude, this is the author, that whiteness exists at the vortex of race in U.S. law and society, and that whites should renounce their racial identity as it is currently constituted in the interest of social justice. So when you look at it, this flexible construct that is whiteness, this malleable thing that can be bent, and that's what this book is basically breaking down, how it starts off as a pseudoscience by the courts citing Blumenbach's 5 races of men in the cases, the prerequisite cases, as they're called, when Asian Americans, namely Chinese people, are trying to be classified as white because they want the same privileges that white folks have in this nation. The courts basically told them, well, you can be black, and they rejected that. They said, no, we see how you treat them people, which lets you know that blackness itself is a fictitious construct. If the courts told the people that they already cited in their cases as yellow folks, as per Bloomingback, as the yellow people, they told them, Chinese folk, that you can be black. And I can read from that excerpt as well. I want to get back to the conversation. Those that follow the channel have heard me read that before, several times before, but it goes to show, and it brings me back ultimately to the question, is this a white man's country? And in that question, you have to make the courts define what whiteness is, because it was never, ever clearly constituted by the way these cases are broken down in this book right here. It is something that has become socially acceptable, but white, like black, are unconstitutional terms, unconstitutional names. They're not in the Constitution. In fact, the only people mentioned in the Constitution, as Brother Ali said earlier, as per our conversations, are Indians not taxed. And that is it. This thing will open up some layers, fam. And we have to get on it. That's why we building right now. And we're gonna get on it. We're gonna get on it. So y'all go in. I just had to insert that part. I had to bring that part home. This whiteness element.
That was an excellent point, bro. Again, I am of the mind that we move away from race, right? And I think that from our consistent conversations about it and the problems with it, I think many people are beginning to understand exactly where we're coming from. You still have people who are holdouts and, that kind of cling to race and the things that some people talk about, the social the social clout that has been built up by way of blackness, right? Particularly blackness. But the interesting thing about blackness is something that I was talking to someone about earlier this week. It's really not that old in terms of its usage on a national scale for the people, because to be honest with you, coming out of slavery, the racial classification for the most part was Negro, and you had other terminologies that were being used, but for the most part was Negro, right? My doing the ancestry work for my family, the stuff that comes up on the census records for my family going back into the 1800s was Negro, right? Largely Negro. You had some mulattoes, right? Because a certain part of my family on my father's side, they were listed as mulattoes. But mostly they were listed as Negro, right? And so this black thing really kind of comes into play like around 1968, circa 1968, somewhere around there. And about 20 years later, the terminology African American comes in around somewhere about 1988. So to be honest with you, the large scale usage of the term black on a national scale is only about 20 years older than the large scale usage of African American on a national scale. So but that's just a little bit of history on that. And obviously we know that the term African American can be found going back into the 1700s with that particular sermon about Cornwallis or whatever, something like that. A lot of people are very much aware of that document now. But I'm just saying, in terms of a large scale usage on a national level, African American around 1988 and black was somewhere around 1968. Because they made a conscious decision that they were going to abandon Negro nationally. They were going to abandon Negro in favor of Black. And so that was kind of a conscious thing, man. There were actual conversations about it. It's a book by a man named Richard B. Moore called The Name Negro, Its Origin and Its Evil Use, that gives a great breakdown on the terminology Negro and where it came from and how it was used, and the fact that there were conferences and conversations about whether or not to continue using Negro, and these people consciously, our people consciously decided to abandon Negro in favor of the identity of Black. Like I said, somewhere around 1968. But in any case, man, I just wanted to drop that little bit of history right there, and we keep the conversation moving. Or you want to close out? It's up to you, because it's been like 2 hours.
Yeah, we at the 2 hour mark. So you was gonna say something, Josh?
Yeah, I just wanted to ask Sister Kamilah, again, I just want to highlight and give kudos to the work that you've been doing out there in California, you and many others of Freedmen doing excellent work moving the reparations conversation and moving the state of California to enact powerful legislation that's going to have ripple effects around the country.
Very
And
important work, Josh. Yes.
yeah, oh yeah, and so we want to lift that up and give that the proper recognition that deserves. And sis, did you have anything that you wanted to make the family aware of on that regard, or any other information that you want to pass along?
I just want to say thank you for the platform. It's always kind of good to be in these spaces, particularly with you all. Iron sharpens iron, so it's just really cool to be able to talk about the law and history and current events, all in a way that works in the favor of our community. So just thank you for the platform again. I do think California is unique in the way that a lot of the arguments, progressive and conservative, kind of come from California, like Edward Bloom, who is the lead petitioner who filed this case on behalf of Asian American students. Before he got to the Supreme Court this time around, he was one of the key, architects around Proposition 209 and the ending affirmative action in California. California was the testing ground for the end of California, for the nation. The same players are here, are at play, essentially. And kind of the inverse of that, we're seeing is going to happen with the reparations space, where California is kind of the political battleground for what reparations might look like, if it even exists at all within our lifetime, which we know it will.
That's right. That's right.
Across the nation. So we're prepped and primed for this moment. Everything happens for a reason. So it's great to be amongst like-minded folks in the reparation space, so that we can finish the work that our ancestors began with. So I'm a bit tired, so I'm a bit rambling, but
No, it's
thank
cool.
you again.
No, but real quick, if you want to tell people what you got going on at Harvard, Brother Otis put that question in the chat.
Oh, right. Okay, so actually I'm going to be in Boston on November 3rd for the Harvard Public Health magazine, as well as the FXB Center for Health and Human Rights. They are hosting a reparation symposium around the question of, can reparations repair like health harms, essentially. And so I'm giving the closing keynote for that. I'm actually working on that right now, refining it a bit. And so, yeah, that's an in-person symposium. So unfortunately, there's not going to be any streaming. And then on November 9th, I'll be at Boston Law School. And I believe there might be a streaming option for that. So I'll keep folks updated. But that is going to be a panel on reparations. I think someone from the ACLU is going to be there and some other folks. So I'm still waiting to get like a flyer for all that. But yeah, November 3rd, the Harvard Public Health and FXB Center for Health and Human Rights is doing a reparations symposium. And then November 9th, Boston Law School is hosting a reparations event as well.
Indeed. Powerful. Our sister is making moves, and thank you for coming on. It's been an honor. And I know we've had discussions before, but having these offline, but having these discussions online so that everybody can see that those of us that are serious about this reparations thing, right? Us reparationists, us on the ground, grassroots reparationists, we can have a conversation about this topic: Supreme Court, affirmative action, and what they're saying about the Freedmen and the 14th Amendment and civil rights legislation. Right? What was the intent, etc. And we can have this conversation in a way that there was this is a historical fact. Ptolemy, I can't remember if it's the first Ptolemy or the second Ptolemy. This is when the Hellenes had taken over Egypt. And, well, Greeks is the name by which we know them historically, but they never knew themselves by the name Greeks. This is a name that's given to them. I don't even know when, because it's been so long since I've looked at some of that stuff. But I know that this name was a name given to them by historians. They were practitioners of Hellenism. And they come across the Jews. And when we say Jews, I know there's some controversy about who is quote unquote black Jews and quote unquote white Jews, but we are talking about white Jews. Ptolemy comes across these Jews, and I believe that's Ptolemy II, I think. And he's intrigued by them. He's intrigued by their knowledge. And he separates them into 72 different rooms. These 72 different scholars. And he asks them, if y'all are so knowledgeable on this topic that this religion that y'all are a part of, as you say, then I want you all to write from your memory. You claim that you have great memories, write from your memory what you've studied, what you've memorized. And they all verbatim, all 72 of these people wrote from memory what they had memorized, and all of it matched up. And that's how it is in this reparationist space. Those of us that are studying the work, we don't have to build with each other every single day. We are studying the same works. We run a lot of information and ideas past each other, in back channels. And we know that if we bring somebody like Sister Kamilah on, everybody's been watching us, but we know she's going to be on point. Everybody knows that she's going to be on point. And the purpose of me saying what I'm saying is that anybody can study to show themselves approved, right? Because anybody can be a reparationist. Only thing you have to do is be an advocate for reparation. There is a body of knowledge, however, that we feel makes one proficient in this space, and which is why some people may consider some of us as quote unquote experts or proficient, versed, etc., etc. And we all should be able to come on the platform and have the same level of conversation that we had with our sister Kamilah tonight. So I just want to give a shout out to our sister and you know, thank her for coming through and showing and proving what we already know and expanding on this conversation, because we were curious to hear her views about what the Supreme Court was saying, being that she is an attorney. And in some ways, we want to test our knowledge, right? To see if we're on point and not too far off of our own interpretations. And that's what we're trying to build here at Be the Power and the United Sons and Daughters of Freedmen. Brother Josh, Brother Ali, did y'all have anything that y'all wanted to share before we close out?
Not really, bro. I think we covered a lot. I just wanted to also extend a special thank you to the sister Kamilah for coming on and joining us. I know she's tired, man, because she's doing a lot, and that sister's busy. But I so appreciate her and what she does, and all of the trailblazers, as I like to call them, out there in California, because that's what they are. You know, they are setting the standard in this uncharted territory that we're in. This reparations thing is uncharted territory. None of us have been here before. None of us have successfully acquired reparations for our people in this country, and so this is all new to all of us in a certain level. And I think that with that being the case, our family out there is like, you know, they're leading the way in this particular charge, and this in action, the actual action of moving forward towards achieving that level of justice. Unprecedented stuff. And then, you know, I have nothing but love and admiration for them, man. And you know, that's what it is. That's real talk.
That's right.
And so with that being the case, I just want to say thank everybody for joining us tonight. Whoever joined, I appreciate you. Respect to the family, and let's just keep moving this thing forward.
Indeed, Brother Josh.
Yeah, man, I just gotta say, look, this has been an extremely powerful Be the Power episode. And this message and this breakdown, this needs to reach the masses of our people. So I would just ask that you do yourself and do our people a favor and just share this out. Share this out. We're gonna probably do some more things with this particular episode, but please share this with your friends, family, share this on social media. And also, we are really looking to make things happen, not just continuing to educate and talk, but to actually try to move this thing forward. So, Brother Naheem, did you want to extend how the invitation for people that want to be a part of making things happen, and not just listening and not just talking, but actually making things happen? Did you want to extend that invitation out to the family?
Yeah, but I think we should talk first. We need to build first.
Okay.
You know,
okay. Well, that's coming soon. As y'all, I know y'all been hearing us say it's coming soon. It's coming soon. We're working. We just want to be building this thing to where we can actually push down on the gas and see some acceleration of this thing moving forward. Not just sit in the car and talk about with the engine running. Right. We want to be able to push the gas on this thing. So look forward to that, y'all. And that's all I got to say. Extremely powerful episode. And I look forward to continuing this conversation, because this is, I mean, everything we've been talking about for the past couple of years, now we're seeing them talk about it on the highest level when it comes to the Supreme Court. So I'm not going to say BTP is always right. I'm not going to say that, because, you know, people don't like when you say things like that. So peace.
Indeed. Well, y'all know we honors brother Marcus Champion and my Cali fam is in the building. Honors sister sister BB. And shout out to our sister BTP Riri. You already know. But before I leave, I want to address, we got a hater in the chat. And y'all know at BTP, every so often we got to address a hater. So this Malcolm Thompson guy said, you are a fraud. You co-sign people that have been anti-reparation like Stepper just because they hate Tariq. You are a joke. So let's address this. I'm gonna address it. First and foremost, I couldn't be a fraud if I tried. If I tried, I couldn't be. I'm just cut from the realest cloth. It just wouldn't even work. It wouldn't work. Wouldn't work.
Shout out to Stepper.
But yeah, I mean, but I want to address this. You co-sign people that have been anti-reparation. I co-sign no one that are anti-reparations. I don't care who it is, Stepper or anybody else. That's first and foremost.
Stepper's not anti-reparation, so that's a bold-faced lie. He's
no
not
doubt,
anti-reparation.
No doubt. But I want to address it though. I don't care who it is. Nobody here co-signs anybody that's anti-reparation. So that's an absolute lie. And he said, like Stepper, just because they hate Tariq, because that's the person or the man that you worship. We don't do that over here. We don't do man worship or woman worship or none of that stuff over here. You take that over there. Don't bring that over here. First and foremost, I gotta address these people because I've been getting came at by a lot of these people that I call Follow and Swallow 2.0 that got FBA in their profiles on Twitter. So I want to address that because we got to get this stuff out of the way. You witness the productive bill. And then on the back end, you see somebody come in the chat at the very end to say something negative because they wanted this response, right? And I could have just shut it down. But in order for us to move forward, family, we're going to have to really, it's easy to ignore, right? And say, yeah, but at times we got to address this stuff. We got to address this stuff because other people that's coming up need to know because they may see this and they may be watching and say, oh, wow, is that true? It's like, no, it's not true. We're not jokes over here. We are 100% serious over here. Point blank, period. And so I gotta address the haters. We've been doing this since we've been doing BTP. Anybody that's anti-reparations, they don't get no cosign over here. So this person came in our chat. And now they're talking a whole bunch of and I'm not even gonna address the rest of that stuff that they're saying. Matter of fact, mods, block this person from the chat, please, because I don't have matter of fact, I can do it. Let me block this guy. Let's get this person out of here so we don't have to keep addressing it.
A lot of them guys, man, they got
fake
some
accounts.
They got fake accounts and they got like a lot of feminine ways and stuff. He's very, very emotional over somebody that he considers his daddy or something that he's got some kind of attraction to this man or something. I don't know what it is, but it's just stupid to me, man. Don't come over here with all of that feminine energy like that, man, because we're trying to be very, we're trying to give real information and talk about real stuff, man, when nobody has time for all of that.
Indeed. But I had to address it. Because some people are crazy, and you got to address the crazy sometimes, just sometimes, because they want to start these little beefs and keep certain stuff going. And we going to address what we going to address. We don't do no man worship over here. BTP follow BTP and our family that we rock with, point blank, period. That's who we follow. I always want that to be clear so that, everybody won't be confused about that. So with that said, family, let us get up off of here. And I'll leave you all with the motto of this platform, which is don't just fight the power, become the power. And then and only then will you have the power to make a change. And with that, I say peace.
Peace.